Hey, everyone, it's Naomi Wolf with Daily Cloud, and we're absolutely thrilled to have Wendy Murphy with us today. She is a professor of law at New England Law Boston. She's been teaching law around sexual harassment and sexual assault for 20 years. She's with the Women's and Children's Advocacy Project at New England Law Boston. She's an impact litigator, and she's also been a visiting scholar at Harvard Law School. Welcome, Wendy Murphy.
Thanks so much for having me. It's great to be here.
It's great to be talking to you. So you've been at the cutting edge, really, of law helping victims, especially female victims and survivors, women and children of sexual violence, assault, discrimination, long before the Me Too movement, long before everyone even understood the issue. And you're here today because of an initiative you have supporting passage of the ERA. So please talk to us a little bit about your background, why you pursued this course of advocacy in law, and then tell us, what's in the news right now that we need to know about.
Yeah, sure. Thanks so much for that introduction, for giving me the opportunity to talk about this stuff. The thing I think that I feel most frustrated about is how little people understand about the Equal Rights Amendment and how important it is to women's lives. And mainstream media really isn't covering it as much as it should. And so someone like you helping us get the word out is really important. So thank you, Naomi. And thank you for your amazing work. I mean, I've known you forever through your work and through your books. And it's just great to connect like this. So thank you again. Yeah. And anyway, all right, back to square one. So I started this work by accident. I'm an accidental activist. I mean, it's really that simple a phrase to describe why I do what I do, because I was a prosecutor focusing on child abuse and sex crimes 30 years ago, more than 30 years ago. And I would be in court watching the judges disproportionately impose certain types of court orders on women, mostly women, and not on robbery victims. So, a rape victim would be ordered to turn over her pediatric records from 25 years ago, and a robbery victim wouldn't. And I would say, Your Honor, you can't do that. You can't treat an entire class of people differently because they happen to have been raped rather than robbed. And that appears to be what the court is doing. I object. And I did it all the time, and it really annoyed the judges until one of them said to me one day, after I'd been a prosecutor for about 5 years, he said, Ms. Murphy, you are the government. Your job is to state the law, not complain about it. If you want to change the law, you have to get a different job. And I'll never forget the moment that he said that, because I remember thinking, well, my goodness, if I'm not supposed to object on behalf of this class of people, and certainly the defense isn't going to object, who protects the system from sex discrimination? And the answer, of course, was no one. So when I left the DA's office, I took the judge's sage advice, left the DA's office and said, well, I'm going to find a way to force feed the system a voice for this class of people. And that's what I've been doing really since the beginning. So beginning of my career as a private practitioner, I just became an activist saying somebody's got to do it. And I know where the missing parts are. I know where the injustices are. So I may as well do it. And I remember thinking, I'll do this for a year or two, and then I'll get a real job as a lawyer. And it's been decades. There's a lot of work to do. So that's really, go ahead.
Yeah, why, just listening as a non-lawyer, that seems so obviously unjust that a rape victim needs to offer her medical records as a victim, going back to her pediatric records. And of course, no one else who's a victim of a crime needs to do anything like that. What was that really in the law, that a rape victim had to provide her medical records going decades back? And yes. What was the justification for that? That's extraordinary.
There really was no justification aside from the fact that it was what the judges were doing. And I would say, I'd say I object. And where was the court getting its authority to do this? And invariably, the court would cite the due process clause on behalf of the accused. But I'd say, but the accused, his rights, his due process rights are important, but they run to the government. So I should have to turn over what's in my file, and I always did, But the victim is a private person, and she's not his opponent, and there's no constitutional relationship, if you will, between the perpetrator and the victim. So the due process argument never worked. But I really do think it was just the comfort level that the courts had with the idea that rape victims ought to be treated worse. It was just a comfort level. And then because there was systemic tolerance for it, it kind of became the norm. But when I raised objections, asking someone to point out in the law where this was actually allowed, there really wasn't anything. That's one of the reasons when I went into private practice, I started filing impact litigation cases against the system, against the courts, against the judges who were issuing these orders, and instructing victims and rape crisis centers and pediatricians to just refuse to comply. Don't just obey.
Right.
Don't just comply.
Let me jump in again, because this is really mind blowing for a woman and a victim. Even, I follow this pretty closely. I'm an activist, and I, as a survivor and as a woman, have never heard anyone say that there is no constitutional relationship between the victim and the alleged perpetrator. Like, I guess what I'm trying to say is, as a woman, you just assume that you're in this disgusting relationship in which you have to justify yourself, within the system of law. You have to be the perfect victim. You have to never have done anything questionable, never have consulted a psychiatrist, never have been unfaithful, never have had an STD, whatever it is, have that perfect medical record going back to infancy in order to be a credible victim. And you're the first person who's telling me that there is nothing in the law that says I have to, as a victim, have any relationship with my accuser. That is important. Can you speak more? Why did judges assume? I get the treating worse, but that's a big deal to assume that the victim's past is admissible by law as part of due process for the accused when there is no such thing in the law. Help me understand that kind of philosophically.
Yeah, well, you just said it exactly right. And this, this example that we're talking about is just one of many similar problems in the law that because we don't change the lens and think about it from a different perspective, we never get at the root problem. And I have always done that. I've always been the one to say, well, I'm not going to accept your premise. I'm going to look at the premise. I'm going to examine the underlying foundation of your argument. Which I think makes me both more effective, but also more dangerous. And right. So I would be the one in the room saying, rather than just assuming the accused has a right to this stuff, can we talk about whether he has a right to it and talk about the foundations of his argument? And occasionally judges would say, well, you're probably right, Ms. Murphy, but since you're here, why don't we just argue the merits? And I would say, no, I'm here out of respect for the court, and I will not argue the merits. I would like to talk about whether he has authority to ask for this material. And sometimes I would say, and I actually did this. It's in my book, actually, I write about this, that I had my own attorney-client file in front of me in a criminal case one time. I was not the criminal prosecutor. I was there on behalf of the victim. The prosecutor was there and the defense attorney was there, but I was there on behalf of her privacy rights because they were trying to get her mental health records that predated the rape, substantially predated the rape. And I said, why should he be able to get these records? Where is his authority? Where does his authority come from? And moreover, what about the privilege that we claim attaches to these records? Both of those things matter. And he said, well, the guy can't make an argument about why he needs the file until he sees what's in there. And I said, but he could say that about anything. I want her grocery receipts. So why don't I just see them and then let you know how I feel about them? I said, Your Honor, I have a file right here. It is filled with statements and conversations I've had with this victim about this case. This is an attorney-client file filled with statements from her actually about the rape. Do you want me to turn my file over? Oh, no. That's attorney-client material. I said, oh, no, but if it's about his due process rights, then why doesn't he get them?
Right.
Ms. Murphy, stop talking. Stop talking. And of course, I would keep talking.
But also a HIPAA law to require the medical records of a victim.
It violates so many things. I mean, I don't even know where to begin. But I don't usually just jump to that argument about what about HIPAA, what about the privilege laws that apply. I don't go there because my first question is always, where is his authority coming from? Your Honor, where is your authority coming from? And when I do that, most of the time, judges will say, as happened in this very famous case, stop talking, Ms. Murphy, stop talking, because they can't actually answer the question. That's the issue.
Look, stop talking, Ms. Murphy. That's extraordinary. Well, can I ask you, as a non-lawyer, are there any other crimes in which the victim is expected to hand over, aspects of his or her past that might undermine him or her credibility? Any other crime?
Well, let me give you an example. So if you walk into the police station and say, I'm here to report a robbery, and the robber just flew in from the planet Zeton, I think it's fair game for the police to say, we'd like to see your mental health records. And I don't mean to make fun of it, but there's a case-specific example of a robbery where the police and prosecutors and the court would likely say, it's really important that we figure out whether this person has some mental health problems that affect their credibility. I don't have a problem with that. Or even if a rape victim walks in and says, I was just raped from a guy from the planet Zeton, fair game, ask her about her mental health history. But what we have in this country is the mere fact of being a woman and a victim. That's it. You got to turn over your entire history.
So you're saying when you are raped, and if you're a woman, you become a category of person whose credibility is suspect enough that you need mental health.
Presumed suspect. Yep. Let me give you another example of a law you've never heard of.
Crazy if you're raped, or possibly crazy.
Yeah. It's absolutely systemic sexism, and it's been in the law for a zillion years. And here's another example. There is a presumption that a woman is not credible, especially when she reports rape. But even if she didn't report rape, there'd be this layer of suspicion. It's just exponentially worse when you report a sexual assault. Another example of a law in this country that is only imposed to harm and undermine rape victims, that is not imposed on other types of crime victims, is the requirement that you must answer the question as a prerequisite to seeking redress, to seeking justice. Have you ever made a false allegation of rape before, or sexual assault? You have to answer that question. If you've made 5 prior false allegations of robbery, you don't have to answer.
Oh my God.
And if you're a robbery victim who's made 5 prior false allegations of rape, you don't have to answer. Only rape victims, only prior false allegations of rape. And there is no statistical support scientifically for the argument that that's a fair question, but it's in every jurisdiction in this country. Another one, let me give you another one. Listen to this one.
Sure.
When a jury is selected, in this country, in almost every state in this country, when a jury is being selected for a rape case, jurors are required to answer the question, have you or anyone close to you ever been the victim of a sexual assault?
No.
And when I was trying cases and we asked that question of the veneer, of the large pool of potential jurors, of course, all the women's arms go up, right? And they get booted. They get booted. Sorry, they almost always get booted. Sometimes a judge will call them up and ask some further questions about whether they're too biased, but generally speaking, they end up getting booted. Guess what we don't ask that same pool of jurors? Have you or anyone close to you ever committed a sexual assault? We don't even ask. The only rapists who get kicked off of juries in rape cases are convicted rapists, but we know that over 90% are never convicted. So basically, who's sitting in judgment in rape cases in this country? Rapists. And who's not sitting in judgment? Victims. Mandatory. Those are 3 major areas of gender bias in this country's legal system that absolutely no one is doing anything about right now.
That's huge, Wendy. That's gigantic. I can't even believe that. I'm stepping outside to get a little more light on our conversation. That's shocking. I mean, that's beyond shocking. That means that explains why it's so hard to get a conviction for rape. I mean, first of all, I just want to validate what you said about statistics. There's this myth that there's higher rates of false rape allegations than other crimes. It's exactly the same, as I understand. 2% of burglary reports are false. 2% of arson reports are false. 2% of rape allegations are false. And the other thing that's extraordinary is that it's very hard to get a conviction in this country. And it's actually hard to get the data on this, I found. Of the reported rapes, 12% even got prosecuted in America, and it's 6% in Britain. And I couldn't even find data on actual convictions. So really, rapists have impunity in this country based on my last round of research. And what you're saying actually explains why it's so difficult to get convictions. There aren't, if those juries were 50% women, of whom everybody knows someone who's been raped and had her life horribly impacted by it, you would have more convictions. That's a systemic guarantee of impunity for rape. Am I understanding this correctly?
Yeah, it is that simple. It is that simple and uncomplicated. And by the way, the number one, well, two quick bits of information about the science on false claims. You're far more likely to get to see a false report of one's own death than a rape. That's been statistically demonstrated. And the most common form of false report of a crime is, and no one's surprised by this, is car theft. Because, and why? Because they want to file an insurance claim and get some cash. So, but what's funny is if you report your car being stolen, no one asks you to turn over your mental health records or anything.
Let us know you're credible. Absolutely right. Oh my God, this is so sobering. I mean, every woman watching this who's a victim or a survivor knows someone who's a victim or survivor is really going to think twice about reporting. I mean, in this case, because you're not going to.
Yes, but let me push back against that, because as an activist, I will fight to the end to prevent any of this stuff from deterring reporting. What I like to say to victims is, report, 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 no matter what. Being heard matters no matter what. Being counted matters no matter what. Don't give them the right to claim we have falsely low numbers, because if you don't report, they get to say we don't have a lot of rapes, and we have gobs and gobs of rapes. They're just not reporting. So report, report, report. Force the data, and then also learn the tricks. Don't just obey the prosecutor and get involved in the system and answer all the questions. One of the problems with rape victims is that they want to tell the truth and they want to cooperate, so they reveal all this stuff when they talk to the police. And the police might ask, have you had sex before? Do you have any mental health problems? Do you have a drug problem? And once that's out, once the victim reveals that information, it gets handed to the perpetrator and his lawyer. So I like to teach victims that they have Miranda rights, much like what we know to be ordinary Miranda rights, the right to remain silent when you're a suspect. Well, guess what? You also have privacy Miranda rights as a victim. When you go to the police station to report a rape, that's all you should be talking about. Not last week, not your mental health problems or treatment, not what you did 5 years ago, not whether you're sexually active, not whether you had sex with 5 men and a goat, just that one incident, right? That moment in time, that guy, what happened, that's it. And if you don't give women the permission they deserve to say that's none of your damn business, when a cop or a prosecutor asks a probing, irrelevant question, then the victim herself has ruined the case by being obedient. So I like to say report, but don't be obedient.
Well, one of the most important things I've ever heard anyone say, it's not well known. I didn't know it. And would you recommend that, if possible, victims bring their lawyers to the courthouse, to the police precinct to report, or bring a legal observer? Like, what's the safest way if, God forbid, someone I love or I gets raped tomorrow? What's the safest way to go report?
Yeah, very, very good question. Never go to the police alone if you can avoid it. Always go with an advocate. And sometimes the police won't let you sit with the advocate when they ask questions, which I think is outrageous and unacceptable. So I always also encourage victims to argue that they are disabled. I know that's a little funky, but PTSD is a very serious disability. It's a recognized disability under the Americans with Disabilities Act, and trauma from rape is real. So if you argue that you're disabled, the moment you show up at the police station, then you can say, as an accommodation for my disability, I would like this person to be here with me. That's a really important trick that we don't teach victims. To characterize themselves as disabled is not shameful. It's not wrong. It's not fake. It's legitimate. And you need that person. Plus, that person can help you protect your rights and protect the integrity of the case. The other thing is, know your rights. just know your rights. If the police
where is this all in one place? Like, will you help us create a what to do checklist if God forbid you're raped and you have to go to the police? Like, that's one page that people can download and laminate. Because where are your rights? No, most people aren't lawyers. Most people aren't sexual assault lawyers. No one knows this.
That's true. And yes, you're right. No one knows this. And even worse, and this won't surprise you, Naomi, you've been around for a while. Many of the so-called advocacy groups that are well known, the establishment groups, are actually working for the government. They're being funded by the government. They're not going to tell you these things. And so, victims tend to go to the places like their local rape crisis center where they think they're going to be protected. And they're not with regard to these rights. Those groups just aren't helpful, and they actually kind of cover up the problem. But because just think about where they get their funding, and if the group you go to is getting government funding, you're already not going to get what you need. I have a business card.
Sorry, jump in for 1 minute. When I called RAINN, RAINN, which is like one of the biggest violence against women organizations, I was reporting on behalf of a friend of mine who was being victimized by a partner with her consent, and they started asking me a lot of informational questions about her and about me, and I was very surprised because in an authentic violence against women hotline support group, you really have to respect the boundaries of the victim reporting and not push. And I did ask, do you get government funding? Is this going to government? Do I have absolute confidentiality in talking to you? And they conceded that I did not, and that was shocking. And I also want to add, when I thought, as a survivor of a sexual assault by a professor at Yale many years ago, I thought I was talking. They kept directing me. I've talked about this too. A putative women's sexual assault support group, and it reported directly to Yale's counsel. And in fact, the head of it, I researched her, and she was an attorney for Yale. And, when I went in and talked to the Yale about the assault and about, later harassment and retaliation, they took everything I said and gave it to counsel. So, people, especially on campus, have to be aware that university police are not municipal police. Check if you're reporting to an entity that reports to the government. Ask questions like, is this confidential? And what else should people do to make sure that they're not handing over information in a way that would hurt them?
Well, the campus thing is even worse than the real world, believe it or not, because they do have this extra layer of privacy. It's a nightmare. I've been doing Title IX work since the early 90s. Cases that I filed against Harvard and Harvard Law School, as well as Princeton, are what led to the Dear Colleague letter in 2011. I mean, I've been pushing really hard to get people to understand that any sexual assault in connection with education is a civil rights issue that should be subject to exactly the same treatment as a racial assault.
Explain what Title IX is and what a Dear Colleague letter is, please.
Yeah, so Title IX, of course, from 1972, most of us know it as a law that protects women's equality in education. But I, like a lot of people, was raised by propaganda to understand Title IX as a sports equity rule that somehow only applies to sports. And so I never thought it applied to me because I didn't play sports. And it was only as a young lawyer that I read it and said, what? Title IX has nothing to do with sports. It's about anti-discrimination. It's a civil rights law. You've got to be kidding me. This is a wonderful tool. I've got to start using it, which I did in the early 90s. And I made it my mission to do activism oriented toward elevating the public understanding of the relationship between Title IX and any form of harm that women endure on campus, from sexual to physical to verbal, all these forms of harm that are under the umbrella of sex discrimination. Just like we understand, if you're a Black student on campus and someone calls you the N-word or beats the hell out of you or sexually violates you because you are Black, that's covered by Title VI. Title VI and Title IX are exactly the same, except Title VI covers race and national origin and Title IX covers sex. Connecting those dots was really important to me in the early 90s with regard to my activism. And I filed lots of cases to try to hammer home that point and get the media to cover these stories. And they did. I mean, by and large, they did. And ultimately, I had a case against Harvard Law School in 2010 simultaneously, I had a different case against Princeton. And both of the cases I filed were with the Office for Civil Rights, which is the government agency that oversees and enforces civil rights laws such as Title VI and Title IX. I filed those cases. They told me they were going to open the cases for investigation. And then I have been doing Title IX work for so long that I knew these problems at Harvard and Princeton were systemic. So I sent both cases, the Princeton and the Harvard Law School case, to DC headquarters of the Office for Civil Rights. So I sent it to the big guys in DC and said, please issue some kind of global guidance rather than just ruling against Harvard Law School and Princeton. Could you issue some kind of global guidance that will apply to all schools? Because, that we've got to be efficient about this. And
is that sexual assault or sexual harassment? What were the, I mean, without going into too much detail, what were the Title IX cases?
Yeah, the cases were both sexual assault cases. But I want to say something very, very important about the phrase sexual harassment. But let me just finish up about, so sending these cases to DC headquarters and asking for some form of global guidance because the problems were systemic in higher education. I also got amicus letters of support from two leading organizations. At the time, very few people were doing this work. So I solicited letters of support from the National Center for Higher Education Risk Management, NCHRM, as well as Security on Campus, the so-called Clery Act people. They both sent letters saying, Wendy's exactly right. You have to issue some form of global guidance because these problems are going on everywhere and schools are not doing it right and so forth, and sexual assault is rampant. And they agreed. And so in April of 2011, Joe Biden went to the University of New Hampshire and announced the Dear Colleague letter. People famously think of it as the Dear Colleague letter. It's basically a letter from the administration, from the Department of Education, announcing, and it was a lengthy letter saying, here's how you need to enforce Title IX. Of course, it applies to sexual assault, just like Title VI applies to racial assault. And of course, you have to be equitable. And of course, you have to treat victims in the following way. And of course, you have to treat all forms of harm against women as a civil rights issue. You can't treat it as a school disciplinary problem like stealing a notebook. It's a civil rights issue that harms all women. A single sexual assault is an offense to women as a class. That's what the Dear Colleague letter said.
Well, thank you so much for your work. I know it's made such a difference. As far as we have to go, that's a huge step forward in understanding sex as a.
But here's what happened. Higher ed hated the Dear Colleague letter, and they spent the next 10 years lobbying to overturn it. And they recently succeeded, which you may know, because we know that Betsy DeVos recently issued new Title IX regulations that completely overturn the Dear Colleague letter. Yeah.
That's shocking. Now you've put the pieces together for me. Did you want to finish telling victims what they need to do when they report, or have we covered? Should go on to the
Yes. So a couple of really important things. One is there's a website called campusaccountability.org that I developed with my students that has a nice checklist of things to think about. And what I say over and over again is, don't trust anyone on campus, and don't trust anyone that the people on campus send you to off campus. For example, there might be a rape crisis center that's close to campus, and you think they're independent because they're not on campus, but the campus funds them. And they won't tell you that. The campus provides funding for them. So they're also doing the school's work. Don't go to them. Call your parents. If you don't feel comfortable calling your parents, call a trusted adult, your aunt, someone not connected to the campus. Critically important. And
clinical things I've ever heard, and they all have like names like empathy and we love you, sister, and they are actually channeling information directly to the university.
They're working for them.
Shocking.
Yeah.
So that I will direct people. I'll also post that page from your website. Thank you for putting together that information. Now let's talk about the ERA and your role in it. We've got about 5 or 10 minutes to do that.
Oh boy, I know. That's what we were going to talk about the whole time. I do have a business card, which I'll also share with you, which has what I call victim privacy Miranda Rights on the back. And maybe you could post that, because it's a card people can carry around that teaches them to say none of your damn business. If anyone on campus or in the police or whatever asks them a quote, probing irrelevant question, it's a very empowering little bit of knowledge on a tiny card. So I'll share that with you and your viewers. The Equal Rights Amendment came along into my life very organically because, of course, doing impact litigation work on behalf of women as a class, naturally I would root my arguments in the Constitution. I've just always done that. And of course I noticed, because this is what I was taught in law school, that when you root your arguments about protections for women, legal protections for women in the Constitution, you get very wobbly protections. You get very meager protections because women are not yet equal under the 14th Amendment. The 14th Amendment, which was adopted in the late 1800s as part of the Reconstruction Amendments, left women out on purpose, just like we were left out of the 15th Amendment, which gave Black men the right to vote, but not Black women, not any women. So, you know, in my effort to do repair work for these big doctrines, of course, I've always had my eye on the ERA, and the chance to do repair work with regard to the ERA came along, although I'd been planning it for a couple of years, with my client, Equal Means Equal. Equal Means Equal has been doing activism around getting the states to ratify the Equal Rights Amendment for a long time. Just as I've been in the courts, they've been in the trenches. And we came together in anticipation of Virginia becoming the last necessary state to ratify earlier this year. In January of 2020, Virginia became the 38th state to ratify. The way Article 5 of the Constitution works, it dictates how the amendments happen and what we need to change our Constitution. And it says as soon as Congress proposes an amendment and then 38 or 3/4 of the states ratify, it becomes part of our law. Well, we know the ERA, alongside Title IX, was passed by Congress in 1972. In a nutshell, Congress said, we're going to give you equality in education under Title IX while you wait around for the states to ratify the ERA, right, which will give you equality everywhere. And it was sent to the states for ratification in 1972. It had a deadline imposed, an illegal deadline imposed at that time. So we didn't make it to 38 states by the time that deadline expired. And then something interesting happened. So the deadline was a 1982 deadline, but then in 1992, Congress validated what we now have as the 27th Amendment. The 27th Amendment basically constitutionalizes protection for congressional pay raises. Why that's a constitutional amendment, who knows? But nonetheless, Congress validated it, and women went crazy because we thought we lost the ERA when the deadline expired. Along comes Congress to validate the 27th Amendment. Well, just take a guess when the 27th Amendment passed Congress, because remember, they gave us 10 years to ratify the ERA. Guess how long Congress got to ratify the 27th?
Immediate pay raise?
203 years.
Oh,
That's how long they got. So it passed Congress in 1789, and they were allowed to take 203 years before the last state ratified. Women went crazy. How do you give us 10 years to ratify, and you give Congress for their pay raises 203 years, and they would have none of it? So women started rallying. We are going to get 3 more states to ratify. They had made it to 35 by the time the deadline expired in 1982. Now they wanted 3 more states to make it to 38, and we did that. And Equal Means Equal was a big part of getting Nevada to ratify in 2017, Illinois to ratify in 2018, and Virginia in 2020. The problem is, as soon as Virginia did its job and ratified, lawsuits started flying to stop the ERA from being perceived as valid because of the deadline that expired. So my lawsuit I filed, the only lawsuit that's been filed on behalf of women as a class is my lawsuit. There's another one in DC, but this is the only one on behalf of women. I filed it in federal court in Massachusetts in January, and I argued that, look, the Constitution says when 38 states ratify, an amendment becomes law. We have 38 states ratifying the ERA, so it is now law. And it states, it's a very simple principle. I don't think people realize how basic and simple it is. It's not complicated. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Who can object?
Who can object? Indeed, who can object?
Who can object? Our lawsuit is pending. I know you have been a supporter of the ERA, of course. Our lawsuit is pending, and we're basically asking the court to rule that the deadline is invalid, therefore the ERA is valid. It's very simple. That's our argument. And if Congress gets 203 years to validate its pay raise amendment, can't we have, 50 years, please, for basic human equality? That's just
like a very reasonable argument. It's not outre. It's based on equality under law. And I think that, on what basis can someone say that one entity gets 2 centuries and another one gets a decade to create an amendment to the Constitution? That doesn't make any sense at all. Why do opponents of the ERA object to it? I mean, what
their argument on the deadline is that Congress put a deadline in the ERA and did not put a deadline in what is now the 27th Amendment. But there's a lot of case law that argues against the validity of the 27th Amendment, even notwithstanding that it had no deadline attached to it, because the Supreme Court in 1921 ruled that the 27th Amendment, even back then, was too old to ratify.
So let me redirect you to a more general question, less lawyerly, if I may. Why do, like, you read the text of the ERA, basically, it's totally unobjectionable. Why are people suing to make it not happen? Why is there propaganda against it? Why hasn't the media ever explained that it's those simple words? Like, what interests are threatened by such a simple clarification that equality applies to everyone regardless of sex?
Well, I think the answer to that question is it's going to be expensive to give women equality. That's what the naysayers would say if you force them to tell the truth. And by expensive, they'll say, you know, we have to pay women equally and all of that. And that I don't think that's going to be more expensive. I think, you know, you pay people equally, you get more productivity. I just don't agree with that. And I actually think giving women, there's research that shows paying women truly equally will help our economy in enormous measurable ways. And, you know, I just don't see the objection, except for the fact, and Naomi, you're going to get this as better than anybody, violence against women is a big business. It's a very big industry. There's pornography, sex trafficking. There's so much money being made off the sale and commodification of women's bodies that if ERA becomes law, which will guarantee women fully equal protection of law for the first time in history, women will be able to make much more effective challenges to those things. You know, it's not going to overturn pornography or turn our world into, you know, a nunnery or whatever. We're not going to become prudes overnight because of the ERA, but it will be a lot harder to get away with financial and sexual exploitation because an entire class of people being subjected to disproportionate harm would be more legally actionable, and it isn't right now.
Okay, so that's the first time anyone's ever explained to me why ERA is necessary, because an argument can be made, and I remember hearing this in the 80s when I was in college when it died and thinking, well, that's kind of reasonable, that women are already protected under law, that you don't need to spell out. So why do you need to spell out sex? It seems like you were just explaining that.
Yeah, I mean, come on. I feel like if you don't yet understand why equality matters, you just need to get educated. Not you. I mean, for people who don't understand the value of equality, that's hard for me to.
No, that's not. But to be fair to critics, that's not what people are saying. They're not saying women shouldn't have equality. They're saying the Constitution already guarantees equal access.
Yeah, but it doesn't, and that's very, very clear. But
explain why ERA and a specific protection for equality on the basis of sex is not already in the Constitution. Why do you need an amendment to spell it out?
Well, because look, women were left out of the 14th Amendment, period. And the first time women were recognized as persons, never mind equal persons, just human persons under the 14th Amendment was in 1971. Prior to 1971, we weren't even persons under the Equal Protection Act.
But now, 20, what will I have as a woman if ERA passes that I don't now have in terms of protection?
Right, I understand. But I think if you understand that when because we're so new to the concept as a protected class of people, we're so new to the 14th Amendment at all. And when the court did give us protection, it said our protection level would be lower than other classes of people. Then you have to ask yourself, well, what does it mean to have lower levels of protection? I use a visual to make it very clear. This is sort of simple, but here's equality and here's inequality. And that space between equality and inequality is where violence against women happens with impunity under the law. And here's a slightly legal technical explanation, but it's important. If you have this level of equality, which is called strict scrutiny review under the law, strict scrutiny means any form of discrimination by the government basically can't pass muster because we are strictly scrutinizing it. And women only get this lesser middle tier, what they call intermediate scrutiny, which is way down here. So it's not as good as strict. Well, guess what the real difference is? If you get strict scrutiny, then if there's any way to rewrite the law to make it less discriminatory, it must be rewritten. Under intermediate scrutiny, if you go into court and say, I want the law rewritten because I can make it less discriminatory if we change the language, the court can say, but that's not required because you're not entitled to actual strict scrutiny. And let me apply it to equal pay. Let me make it this simple. If you go to the legislature and you pass a law that says women now must receive equal pay, and it looks beautiful because it actually says equal pay, and so equal must mean equal, right? Wrong. When you go to court to enforce the meaning of the word equal under these so-called new equal pay laws, the court doesn't have to construe the word equal to mean actually equal. Why? Because they always construe laws under the 14th Amendment, and we're not there yet.
So that, to me, let me jump in as an audience member and say what you just said is the most persuasive reason to pass the ERA, but nobody knows it. And not to blame, the advocates, but I've never heard a proponent of the ERA explain clearly that in 1971, women were construed legally as less than equal in a decision. That's a super important thing to communicate, and that the ERA would correct it. So I'm just highlighting that because sometimes the left or activists are doing all the right things and not getting anywhere. And sometimes we're not that good at messaging. And honestly, the messaging around the ERA, which is why I'm so glad that you and Equal Means Equal are on the scene, has been very muddy at times. Like, I really tried to understand why I should support it and be able to explain it to people. I haven't been able to. And now you've given me tools to do so. So can you give me a single example? Say you pass ERA, right? And now I wish you well, because it sounds like absolutely it needs to be part of our system of laws, and that's nonpartisan. What could I do tomorrow that I couldn't do yesterday?
Perfect example. And by the way, the 1971 law that made us barely persons but put us on par with stuff got elevated to intermediate scrutiny in 1976, and we haven't gone anywhere since then. So we're still stuck at intermediate. The 1971 case put us even lower than intermediate, just to clarify things.
At home, just to you and all the people in the ERA. I mean, I know you're not asking me for feedback, but the intermediate scrutiny argument is a sucky reality. I think it resonates in our bones. Like, that's what we get. Is it like intermediate scrutiny of our equality? That's exactly where we live. So please.
And I call it second class. I just call it second class legal protections. Whether you don't have to use fancy legal words like intermediate, it's second class.
Because people need to understand why is it second class? Like what? Because the Constitution doesn't say women are second class citizens. Chattel, but you've just explained how we end up in a second class reality. Please, hammer that home. So having said that, what can I do tomorrow?
So give you a stark example. And one of the reasons I filed in Massachusetts, where I live, is that we actually have a law on the books, and this is true in about half the states. So this would happen in half the states if ERA becomes valid. Women are not protected under hate crime laws. They're just excluded. So in Massachusetts, every single category of human is protected. In 2012, sexual orientation, race, religion, disability, national origin, anything you can think of. In 2012, the legislature added transgender as its own category, and specifically, advocates who push for that specifically said, we don't want to add sex or gender. So women are only protected in Massachusetts if they used to be men. And I don't mean that to be anything about the trans community. I'm just saying those are the only women who are protected. If they are trans women or if they used to be men, think about that. Yet the category of people who suffers the most harm because of who they are in society is women. 5 women die every day from domestic violence from men in this country. 5 a day because they are female. That would be a lower number. It would be lower than 5 per day. I don't know how much lower it would go. It would be lower if women were protected under hate crime laws, because it would be an added form of redress, that being targeted because you're female is its own category. And maybe even more importantly, it's not so much how much will hate crimes help, although there's some science that says adding a category of people to the hate crime law does help protect them from violence. But it's really about this very visible exclusion of women. It's like a visual, here's a piece of law that intentionally does not protect women, and women are suffering so terribly. That would change overnight, Naomi. That would change overnight. Wow. But there are so many other things. You know, we talked earlier about rape laws, right? Yes, every single one of those examples where I told you women are required to report, required to reveal confidential documents that robbery victims are not. Women are required to answer the question, you know, have you ever made a false allegation of rape before? Which, by the way, battered women often recant allegations so they can save their lives or save their children. Yes, those are considered false allegations. Put a target on their backs under this system, right? And then the jurors. I mean, the notion that you get bumped as a juror because you knew someone who was a rape victim, but you don't get bumped as a juror because you've been a rapist. These are laws that would change overnight.
It was okay. That's powerful. Well, you've sold me. Many people watching will be sold as well. We can certainly have a follow-up conversation to drill down deeper into what practically will change. And I have to say, I live part-time in Massachusetts, and that is very sobering that Massachusetts protects many categories of people from hate crime, but not me and my daughter. You know, that unless you, you know, yeah, that's shocking. So that's a lot to think about. And how can people watching this help you if they are, you know, persuaded by you? And again, it sounds like a transpartisan issue to me. How can they help you with what you're doing?
There's so much work to do. All they have to do is reach out, because starting grassroots activism around these issues is pretty easy. You just need leadership. We don't have good leadership in this country. We don't have good leadership for women's movement issues generally. And that frustrates me. I mean, I've been talking for a while about creating a new women's party. I think we really need it for political and other reasons. But young people are going to make that happen, not me. I've been around too long.
I'm going to push back a little bit, because our job here at Daily Clout is to actually, you know, explain these difficult things, but then give people a thing they can do that everyone can do. So I'm sure that, I mean, you have a campaign, right? Or you have.
Oh, yeah, people can reach out. Naomi, I'm sorry, I didn't mean to misstate that. I'm saying there's so much work to do that all you have to do is ask. And we've got lots and lots of projects and ideas and things that can be done. Grassroots is the key to success, and young people. So please reach out to me, email me. You can reach me through my law school's website, wmurphy@nesl.edu. You can reach out to Equal Means Equal. They've got lots of stuff that they're doing that's a little bit different than the legal stuff I do, but equalmeansequal.org, excellent to reach out to them. We got a long way to go, but there's also a lot of energy right now, because women are beside themselves. I think we've reached the end of our rope, really.
Absolutely agreed. So it's equalmeansequal.org. It's Wendy Murphy, and we'll post your contact information in the text with this video when it goes online. And is there anything that people can do to kind of, legally and ethically lobby this judge, or is that considered inappropriate?
You can't lobby a judge. You can write a letter if you feel strongly about the case. You could file an amicus brief. Courts are different than legislatures, so lobbying isn't a traditional way to go about it. But we've got a long way to go with our court case. No matter what happens with this single judge that we're before right now, there's always a possibility of an appeal to the First Circuit. And certainly the United States Supreme Court is likely to become interested in this case, because we ask some very important and unprecedented questions.
So to raise awareness that this case is going forward, I find as a reporter that's always helpful, because then everyone, judges, prosecutors, defense, everybody knows that, you know, their eyes on the outcome. How would people tweet about, I mean, you know, what is the headline? Like, there's a lawsuit that you've made. What's the name of the case?
Yeah, the case is called Equal Means Equal versus Ferrero. And if they go to equalmeansequal.org, you'll find lots of stuff about the case there. Some of the pleadings, some of the briefs I've written, some of the amicus briefs we've had filed in our behalf. The U.S. Conference of Mayors has supported us. The Teamsters have supported us, SAG-AFTRA, the United Church of Christ. We have an incredibly diverse group of supporters. And so there's just a great amount of energy But if people want to learn more and tweet about it or use Instagram or all these other youthful things that people do,
It's equal.org.
equal.org, exactly. And I'm available on Twitter at WMurphyLaw. And I tweet about it all the time. You know, it's what we need.
Highlighting, this case. Everyone who cares about this can highlight this case. Reach out to Wendy Murphy. The organization is equal.org. And thank you so much for being available to be a resource for people who are reaching out and saying, what can I do in addition to shining a light on this? ERA, everybody, we're nonpartisan, but this seems like a really nonpartisan way to protect every woman in America. Thank you so much, Wendy Murphy. You're welcome back anytime. This is Naomi Wolf with Daily Clout. Thank you. Tuning in. Bye-bye.